How to terminate unsecured debt using legal and administrative tools. Understanding legal avenues for debt termination. Unsecured debt can be lawfully and effectively addressed using various legal instruments and principles. The Fair Debt Collection Practices Act, FDCPA, offers consumers a powerful defense against unlawful debt collection efforts, while the Fair Credit Reporting Act, FCRA, provides remedies for restoring credit history. By understanding basic contract law, generally accepted accounting principles, GAAP, and court procedural rules, individuals can confront creditors and debt collectors with confidence. One key defense involves challenging the legal right of an assignee, such as a third-party debt collector, to enforce a claim. Since assignees typically have no original contract with the debtor, they lack contractual privity, a necessary element to establish enforcement rights. The banking illusion: no real loans occur. Contrary to popular belief, banks do not loan money in the conventional sense. Under Federal Reserve regulations and GAAP's matching principle, banks are restricted from loaning either depositor funds or their own reserves. Instead, when a customer submits a credit application or promissory note, the bank converts it into a negotiable instrument, essentially a check, and redeposits it as an asset. This transaction funds the customer's own line of credit. In essence, the customer is the true creditor, creating the money supply through their signature. Banks obscure this reality behind what appears to be a formal loan approval process, perpetuating the illusion that funds are loaned by the bank. Strategic engagement with original creditors. To neutralize a creditor's claim, one may issue a notice of final payment. This notice establishes terms under which the debt is considered paid in full. If the creditor fails to dispute these terms in writing within a reasonable time, it may constitute tacit acceptance. Such acceptance, even if passive, makes it difficult for the creditor to assert further claims on the account. It is common for creditors to initiate contact via phone calls. During such interactions, record essential information including the caller's name, organization, mailing address, phone/fax number, and time/date of the call. Then, request all future communications be conducted in writing and promptly end the call. Follow up with written correspondence to reiterate this request. Handling persistent calls and collection assignments. If phone contact continues, repeat the process or file a complaint with your state attorney general's office. Creditors often respond by assigning the account to a collection agency. Once in the hands of a third party, the debt falls under the strict regulations of the FDCPA. A debt assignment does not automatically create a binding contract with the new collector. Without your consent, no valid agreement exists between you and the third party. Often, consent is obtained through deception, inducing you to unknowingly form a new obligation. Debt validation, a legal right. Under the FDCPA, consumers have the right to request validation of the debt. Most collectors cannot produce legitimate documentation such as a signed contract, evidence of product or service delivery, or proof of payment. Absent such documentation, the debt lacks legal enforceability. Typically, collectors abandon collection efforts when confronted with a well-written validation request. If they continue to ignore your request, a formal complaint to the Federal Trade Commission, FTC, is appropriate. Often, simply listing the FTC's address on a second notice yields results.